All right, welcome to our live virtual litigation practice area info and networking session. My name is Albert from Summer Associate Hub. I'm proud to have all of you here. This is a great way to kick off our Summer Associate Hub live virtual practice area series, where students can learn about what it's actually like to work in BigLaw, different practice areas, and prepare for the recruiting process by understanding better what different practice areas mean. We have a truly all-star panel of litigation attorneys today. I'm excited to get into it. So people use the term litigation, but it covers a broad set of practices: trial litigation, appellate litigation, white collar, criminal litigation, antitrust litigation, arbitration, and other areas. All of these different areas of litigation have different skill sets, different required expertise. You may love working in one, but not the other, but they also have a lot in common. And this session will help you go a level deeper in thinking about what type of work you might want to do. So the agenda is as follows. We'll have a panel discussion featuring our attorneys from Williams and Connolly, Goodwin, Willkie, Wilson Sonsini, and Fenwick. That'll be about 30 to 40 minutes, including Q&A. After the panel discussion, each firm will host a separate Zoom room for those who want to join, ask questions, or listen to hear more about the firm. We're going to send the Zoom links in the chat that each firm will be joining, so don't worry about that. In the meantime, you can use the Q&A function to ask questions for the panel generally, and we can tee those up later. And before we wrap up the panel discussion, we'll also have some prize raffles for firm swag. So each firm very graciously sponsored some fun prizes, which we'll raffle off. We'll send a link in the chat function for you to sign up for the raffle. Please note that if you sign up for the raffle, you have to be present to win, and we will call your name out loud. Okay, so don't go anywhere if you want to win some cool firm swag. So before we jump into the panel, quick intro. What is Summer Associate Hub? Summer Associate Hub is a free content and resource hub for law students embarking on the 1L and 2L recruiting process. I'm a former law student and BigLaw associate. We know from our own experience how hard it is as a 1L to understand what it's really like to work at a law firm. Our platform, summerassociatehub.com, has blog posts, podcast episodes, short video tutorials and exercises, interviews with attorneys, and other content to help you learn about practice areas and prepare for the recruiting process. We also host live virtual programs. You know about that because you're watching one right now, where students can easily learn directly from and network with law firm attorneys and recruiting team members. We have a ton of awesome programs scheduled for the spring semester, including an entire series of virtual programs where students can hear directly from attorneys at top firms about different office locations, different practice areas. And all those sessions will have breakout rooms as well. We're also planning an in-person networking opportunity this summer in New York, so stay tuned for that as well. The link to RSVP for those other sessions will be posted in the chat. What we have coming up, we have a DC location showcase this Monday. We have an IP, intellectual property practice area showcase next Tuesday, a week from today. After that, we have corporate and M&A. We have Bay Area, and we have a few others after that, so definitely stay tuned and sign up. The best way to stay updated is to sign up for our newsletter at summerassociatehub.com/newsletter. If you signed up for this event, you're in luck because that means that we automatically added you to our newsletter. So that's good stuff. All right, so let's get started. Instead of me introducing everyone, I'll just let everyone introduce themselves. So let's start. Introduce yourself and your practice, and briefly why you chose to be a litigator. So Alex from Goodwin, we'll start with you.
Hi, everybody. Good evening and good afternoon for those on the West Coast, I guess. Alex Valenti. I'm an IP litigation partner at Goodwin in our New York office. And sorry, I already forgot the question, why I chose to be a litigator. I became a lawyer to be a litigator. I always wanted to do trial work. And so for me, it was really a question of what type of litigation, not whether litigation. I love to argue. I guess that's cliche, but it's true, so.
Great. I'm just going to go in order on my screen. So Mo, why don't you chime in next?
Hey, everyone. Nice to be here. Thank you, Albert. I'm a partner in the New York office of Wilson Sonsini. I've been there for 14 years. Prior to that, I was a federal prosecutor in Brooklyn, and before that, I was a state prosecutor also in Brooklyn. I went to law school having no idea what I wanted to do as a lawyer. I had never stepped foot in a law firm and had seen a couple on TV, but that's it. I got there to law school, and there was a mandatory trial ad class, which I reluctantly took at the end of finals because I had no choice. And I fell in love with it, thought it was awesome, took to it, was way better than regular classes. And then I had to figure out how I could ever do this. And it quickly became apparent that the fastest way to actually be in court and try cases back in New York City was to work at a district attorney's office. So applied to 3 jobs, counties in New York City, and got one of them and started my career. And that naturally eventually led to a job at the U.S. Attorney's Office, and then eventually BigLaw. So I have a little bit of an unusual route from to BigLaw, in that I got here in my 13th year of being a lawyer. And now I do white collar criminal defense mostly, and other trial work. I've become a civil litigator in my later years, but that's how I got here, and that's why I got here.
Great. So, Edon, tell us more about you.
Wasn't quick enough on the unmute. Great. So I'm Eden Schiffman. I'm a partner at Williams & Connolly. I have at this point sort of a broad-ranging practice. I think of it as having three different pieces. One is civil litigation, commercial litigation, and that's pretty broad. Typically, it might be two businesses having a contractual dispute or something like that, a joint venture gone wrong. The second aspect of my practice is criminal defense and investigations, and that's pretty broad. Everything from the occasional street crime case to sanctions evasion, public corruption, that kind of stuff. And then finally, and sort of overlaying all of this as well, is I have an appellate practice, which is when you appeal things either to the Court of Appeals in the state or federal system, or ultimately to the Supreme Court. And that's sort of a trans-substantive aspect of my practice that covers civil, criminal. A lot of times I take on appeals that I wasn't involved in the case below, just because they're interesting issues. And in terms of why I chose to be a litigator, I identify with a lot of what Mo and Alex have said already. But I guess I would say three things. The first is it's just gives you exposure to an incredibly broad range of subject areas. Every case is different. You can go from subject area to subject area, but even within subject areas, every case is pretty different. Secondly, is it really involves a combination of what I think of as fact work and law work. A significant part of being a litigator is investigating the facts, figuring out what happened, whether that means looking at documents, interviewing witnesses, whatever else. Sometimes it really does feel like you're a little bit of a PI. And then there's overlaying it legal questions that can be super interesting, where you get to argue about policy or the text of a statute or something like that. And then the third thing is that it's adversarial in nature. I totally agree with Alex about liking to argue. I think I come from a family without any lawyers in it, and when I was a kid, people told me, "Oh, you like to argue, you could be a lawyer." And I think if that describes you, then litigation might be the right path. Because the thing that separates it to some extent from other types of legal practice is it is adversarial. And at the end of the day, there are usually winners and losers. And that appeals to me, and it makes it really fun.
Great. So Wes, you're next.
Hi, everyone. I'm Wes Powell. I'm a partner at Willkie Farr, and I am the co-chair of both our antitrust practice group and our pro bono practice. And I think that the main reason that I became a litigator is that when I got to law school, I had a sense that I wanted somehow to have both a business practice and also be involved in public interest work in some capacity. And from talking to professors, it seems like pro bono was going to be in my future. And so that best fit a litigation practice, as I thought. Although now that I chair a pro bono practice, I can tell you that we have great work for transactional lawyers to do as well. But that's really, I think, that was the primary impetus for that. And so about 30 years later from law school, I'm spending my time litigating antitrust matters and supervising an enormous number of pro bono matters. And it's a great mix to have in a practice.
Stick. So Alan, finish us off.
Hi, everyone. Alan Wang, partner in the patent litigation group at Fenwick. I'm based in Silicon Valley in our Mountain View office. I like to call what I do litigation for nerds. It is basically, all the people that studied electrical engineering, computer science, all that kind of stuff, who then somehow found their way through law school. That's what I do. We look into really interesting subject matter, ranging from AI to speech recognition to image processing, video streaming. It runs the gamut. And how I got here is a little unusual. I used to be a software developer, and I wrote the most incredibly boring software you can imagine, working for a large company in the Silicon Valley. It was corporate cost management accounting software for large enterprises. That is exactly as uninteresting as you think it is. So I was looking for something else after my first career and decided to go to law school. And the two things that reformed engineers can do, usually, not saying you can't do corporate work, but it relates to patents, right? So there's patent prosecution that's interacting with the US Patent Office to try to get patents, and there's patent litigation. And I tried both. Turned out that I didn't like patent prosecution very much. This sort of reflects what everyone else on the panel has said. There's an aspect of the adversarial nature and winning that is just really, really enticing. And so that's how I found myself here in patent lit.
Great. So one of the best things about this panel is that there's so many different sub-practices within litigation represented. So I think hearing about in each of these in more detail is going to be great. So let's start with Mo. What are the typical matters that you'd work on day to day? Kind of if we were to follow you around day to day, what is the typical matters you'd work on as a litigator focusing on white collar investigations work?
Sure. I guess it falls into a couple buckets. One is an easy one to understand. I represent individual people who are either charged with crimes, typically white collar crimes, fraud and corruption and things of that nature, usually by a U.S. Attorney's Office or the Department of Justice in federal court, but sometimes in state court by a district attorney's office. They're either charged with a crime or they're in the government's crosshairs. And I'm trying to talk the government out of charging them. And when I can't do that, or I come in later and the case is, and the individual has been charged, and it's either a situation where I'm trying to work out the best resolution possible through some sort of plea bargain, or I'm fighting the case and ultimately going to trial. White collar cases often go to trial. There's a variety of defenses that typically come up, but it tends to end up in court. People's liberties at stake, typically, and people don't like to give that up. So that's a big part of what I do. Probably compared to other big law partners, I think I probably do more than that than the average person who does this stuff. I think that is part the type of practice that I like. But the rest of what I do falls in probably two other buckets. One is what we call sort of internal investigations. There's some wrongdoing at a company typically, and the board or management wants to understand what happened, and they hire outside lawyers to come in and try to get to the bottom of it. And if there's a crime or wrongdoing, take some action or recommend some action, whether that be terminating people, reporting the conduct to authorities, potentially negotiating with authorities like the Department of Justice on a resolution for the company. That's what we sort of call internal investigations, and they can really run the gamut. Everything from very serious HR situations to accounting malfeasance, insider trading at the company. I mean, it could be all sorts of things, that whatever the company wants to investigate or needs to investigate, or its board needs to investigate. And then I think everything else sort of falls into a category of interfacing with regulators. Companies oftentimes receive subpoenas from federal prosecutors and need to respond to them. Companies sometimes receive civil investigative demands where regulators want to understand their business practices and make sure they're legitimate. Sometimes there's malfeasance by an individual within a company, and it falls on the company to have to deal with the prosecutors or the regulators investigating that individual. And I help sort of interface with those regulators, because there's nothing that scares a general counsel more than having to deal with the Department of Justice. And so that's where we come in. So I think it really falls into those three categories. As an aside, in the bucket of individual representation, a big part of my practice is taking on pro bono matters for indigent defendants in criminal cases. So, while on Monday I could be dealing with an insider trader who's a gazillionaire, on Tuesday I could be representing, the girlfriend of some drug lord who finds herself in the crosshairs of the government, and I'm trying to help her extract herself from a dire situation. So that's sort of the sorts of things I do on a daily basis. There's variations on all that, but that's the gist of it.
If we say my day involves neither of those things, but that's great. So talked about criminal matters. Let's move to civil matters. Ed, tell us what your day to day is like in typical matters you'd work on with civil litigation.
Sure. So as I mentioned earlier, I think one of the great things about civil litigation is how broad it can be. I mean, some of the traditional types of cases that you get in a civil practice include breach of contract claims of all sorts of flavors. I mean, sometimes it's a simple contract where somebody didn't get the widgets they ordered, but as regularly, particularly if you're going to a large law firm, the breach of contract cases can be pretty interesting. For example, two large developers who were going to cooperate on the complete rejuvenation of a downtown of a major city. And then in the middle of the process, things go sideways. It's kind of a corporate divorce situation. And that ultimately is a breach of contract case. Can involve the sale of interesting assets. So that's one major category. Another might be, torts. A lot of this is the stuff that you'll learn as a 1L or do learn as a 1L in law school. Could be torts, product liability matters. I don't do quite as many product liability matters, but that's a huge part of BigLaw civil litigation practice generally. But to emphasize how broad-based it can be, in the last 12 months, I've had, some of my largest cases have been one involving alleged violations of the Trafficking Victims Protection Act, another involving alleged violations of the Anti-Terrorism Act, where there were accusations that somebody aided and abetted international terrorism, and another contract dispute involving the sale of a professional sports team. And then in one case, I was hired to, by a university to sue the athletic conference that they were a part of for interfering in their season for one of their sports programs. It's all different sorts of stuff, which keeps it very interesting. The main thing with civil litigation, while there is civil litigation against the government, that's Mo mentioned some of that, for example, civil investigative demands or civil enforcement actions by the SEC, for example. The typical civil litigation involves private parties on both sides suing each other for all sorts of either money or control of an asset or something like that. And every day is different depending on where in the life cycle of the case you are. It might involve briefing, a motion to dismiss, or going out and doing witness interviews or depositions, or similarly, those cases also go to trial. Arbitrations certainly go to trial, where you're going in front of a judge or an arbitrator and trying to convince them that your client has the right view of what happened, and the justice is served by giving your client what they're asking for.
Great. Super quick before we move to the next panelist, we're getting feedback that folks are having problems saving the breakout room links. I just sent a Word document in the chat that is easy to download. Hopefully, if anyone's having trouble with it, please let me know in the Q&A. Great. So Wes, tell us day to day, what is it like working on antitrust matters?
Sure. So the very cool thing about antitrust, I think, is just how varied it is. So I think of it as having sort of four categories of antitrust matters. The first, and is the one that I spend most of my time these days working on is essentially merger advocacy. So we represent clients who are seeking to acquire another company before the FTC and DOJ, which have authority to review transactions to determine if they have anti-competitive effects. So what I spend a lot of my time doing is counseling clients, talking to them about, whether a deal they have in mind, will or will not have a challenging path before the antitrust agencies. And then when a deal is signed and the antitrust agency investigates, we go visit the FTC and the DOJ, and we're trying to persuade them that there's nothing to see here, that the deal is totally pro-competitive and no reason to worry. If that doesn't succeed, you may end up in merger litigation. And that usually takes the form of an expedited, a motion for preliminary injunction that the FTC or DOJ brings in order to stop the companies from closing on the transaction. And that's a fast and furious, 6 to 7 month litigation that usually, determines whether or not the deal will happen. But in many ways, it's just like any other type of litigation. And an example is, and this is all public, I represent Choice Hotels as their antitrust lawyer in their current attempt to take over Wyndham Hotels. So it's a very fast sort of practice that we have there. And then there is just civil litigation, much like any other type of civil litigation where one party is suing another for some antitrust violation, and it could be a class action or just a business-to-business dispute, and that has all of the sort of cadence of any other litigation, complaints, motions to dismiss, negotiating settlements, trials, etc. Then there are, sort of other civil governmental action. So the DOJ and FTC or state AGs can investigate all sorts of other antitrust activity, and they may choose to bring a case based on that. So for example, the FTC investigated Amazon for many months, and then a couple months ago brought the big monopolization case against Amazon. And then there is criminal practice, which is the one thing that I don't do. And that really is, those are typically conspiracy cases, much like, Mo may do it as part of his work, because you don't necessarily have to be an antitrust lawyer to do it. Because it's just
All right, so we have two IP litigators on the panel. So I guess Alex, I'll start with you. Tell us more about your day-to-day as an IP litigator working within pharmaceuticals and life sciences.
Thanks, sure. So I guess to start, IP litigation generally, I think refers to any litigation over patents, copyrights, trademark, trade secrets. And so I do a little bit of all of that, but Albert is right. I have a specialty in the life sciences industry. And so filtering down to those types of matters, which is, a majority of my practice, that's representing biotech, pharma, medical device clients in litigation about IP. Usually that's patents. Sometimes it involves other types of IP as well. And so, just to give a couple examples of the types of things I'm working on right now, I'm representing a medical device manufacturer. They make a wearable insulin patch pump that treats individuals with diabetes in a very big and fast-paced trade secret litigation that's pending in the District of Massachusetts. I'm representing various pharmaceutical clients in patent litigation dealing with called Hatch-Waxman litigation, which I'll get to in a second, but dealing with, whether those companies can bring generic versions of branded medicines to market before the patents that claim those branded medicines expire. And I have an arbitration that has a hearing in a couple weeks on what is not really IP litigation in its truest sense of the word, but has to do with a commercial dispute over an IP licensing agreement. And so those are the kinds of matters that come across my desk as well. So I'm echoing some of the themes you heard from others. I mean, even within a focus in one industry, I'll say that it's very varied. Every case brings with it an opportunity to learn something new. You know, I'm becoming an expert on the treatment of diabetes by virtue of representing this client in the trade secret litigation. And my next case will give me an opportunity to learn something new about a different type of technology. So that's what really keeps it interesting for me and also meaningful. I mean, I've had cases where you know, a few years back, I was representing a generic pharmaceutical company in a case where they were trying to bring the first generic version of Suboxone, which is a treatment for opioid addiction, to market. And that was a really big public health, you know, sort of context to the litigation. And sure, we were basically fighting about patents, but at the end of the day, we got a cheaper version of that medicine to market years really before it otherwise would have. So I find that very kind of personally fulfilling as well. So I kind of, not without getting too deep in the weeds, but specific to the life sciences area are two kinds of patent litigation: Hatch-Waxman litigation for what we call small molecule drugs, and the BPCIA, which is an acronym, the name of which I'm not going to be able to remember off the top of my head right now, but it's basically for biologics or big molecule products. And so it's kind of whole other subspecialty within life sciences, a specific type of patent litigation that, like I said, governs when usually lower cost versions of branded medicines can come to market. So I've done a little bit of all of that. Another thing I'll mention about IP that I've found really interesting and fulfilling is, you know, I was a moot court person when I was at Georgetown, and I wanted to work on appeals like most, you know, gunners at law schools who are on their moot court teams, you know, like to do. And, you know, I was a little bit wary of being sort of a district court litigator instead of an appellate litigator, but I actually get a lot of opportunity to work on appeals now. All appeals and patent cases go to the U.S. Court of Appeals for the Federal Circuit. So it's kind of like our mini federal Supreme Court for patent cases. A lot of cases, most cases really get appealed if they make it to any kind of, you know, late stage in the case, summary judgment or trial. And we handle a lot of appeals, both in cases I tried at the district court level, but also cases that kind of come new to our firm who want to work with our IP and appellate litigators at that level. So I'm happy to answer any questions once we go to the breakout rooms and talk in more detail about any of that.
Great. And Alan, tell us about your day-to-day working as an IP litigator within technology.
Sure. So I'll echo a lot of what Alex said, because basically I do IP litigation with a heavy focus on patent litigation, and really it's just the subject matter is different, right? Like, excuse me. I focus on high tech, so most of my clients are going to be large tech companies or maybe smaller tech companies that are facing some patent issues or other IP issues, and this is all civil litigation, right? Litigation is still litigation. We still have everything that folks on the panel have already spoken about. So motions, discovery, witness interviews, depositions, all your legal writing and research. And what we're trying to do is the same thing that all litigators are trying to do at the end, which is come up with a story for trial. What can be unique sometimes for high tech, especially when you're digging into really esoteric stuff like how does a neural network actually operate? How does that plug into consumer products that you're seeing on the shelves? How do you get a room full of ordinary folks, right? The jury and your judge who may not have a background in the area, how do you get them to understand that? So that's one of the really interesting aspects of the job. And related to patent litigation, which pretty frequently in high tech, but I'm pretty sure also in pharma, there are some other venues outside of district court that come into play. So we do some actions in front of the patent office, known as inter partes reviews. These are basically a chance for people who are facing a lawsuit where they're getting accused of infringing a patent to go to the patent office and say, you may have made a mistake in issuing this patent. Here's some more information. And that's like a whole mini litigation in and of itself. Another venue is the International Trade Commission, where a patent holder can say, you know, I want the US government to block importation of all of these devices because they infringe my patents. And that's a whole other thing. And what happens often these days is, especially in larger cases or where the patent holder has deeper pockets, is this will involve things that are at the ITC in district court, and then the defendant will file IPRs, the inter-parties reviews at the patent office, and it's just this crazy, like, huge, multifaceted case. Maybe one of the other things that is relatively unique to IP litigation is we find ourselves working a lot with technical experts. So these are going to be professors, researchers, leaders in the field, scientists, people who present at conventions, and we work closely with them to write an expert report, which is really like a treatise on the accused products or the patents. And it's all about finding out the history of the development in the field of the product. It's all about looking at the development of the accused products. And as part of this, we do sometimes get to do fun things like go on eBay and buy some old products, take them apart, see how they work, try to install stuff on old machines. And that's just part of the job. You just buy lots of cool stuff on eBay and take it apart, learn how it works. There's just a really quick story. There was a case I worked on a little while ago where we needed to basically figure out how to download information from a PDA. So this was like from maybe 20 plus years ago. Before smartphones, there were the personal digital assistants like Palm Pilots and stuff. And there is an archaic file format. And we wanted the calendar that was in this PDA that the opposing party thought we probably wouldn't be able to read, so they made it available for inspection. So we went on eBay and we bought old computers, connectors, cables, an old model of that same PDA, and figured out which software to install and how, and we brought that with us to inspect their device, and were able to download something that was really useful for us in the case.
Awesome. A couple common themes. I mean, even within sub-practices of litigation, I think you'll see from all of the panelists, you do a lot of different things, which always keeps it interesting. And also one thing that litigators always mention is being able to really learn something new and get really deep in a topic. And that's also something that I think you'll see is running through all the experiences among the panelists. All right, so we have a little bit of time left. So briefly, any student who's on here is interested in litigation, presumably. So Eden and Mo, would love for you to chime in here briefly. What are the main differences in your experience between civil and criminal matters? And I guess what do you enjoy about each of those? So we'd love to hear from both of you briefly on that.
Mo, do you want to go first?
Either way, you want to kick us off? You go for it.
Sure. This might actually be surprising to many people because we exalt our criminal justice. Well, many people exalt our criminal justice system as being focused on fairness. But one of the major differences is, in a lot of ways, civil litigation is much more robust than criminal litigation. There are a lot fewer opportunities for things like depositions. Discovery is a lot more limited. You often have to fight tooth and nail to get discovery, whether it's third-party discovery or discovery from the government. One thing we frequently do is, try to get the case to backfire on the government by getting absolutely as much discovery from them, from their investigators, from other agencies that were involved, from their witnesses as we can. And just the way that the rules are set up, you really have to fight tooth and nail to get that in the criminal system, more so than in the civil system, where there's a bit of a, everybody gets often, also it seems, unlimited discovery. And then the other thing that I would say just briefly is that there's a difference between, maybe my ideal setup, we were talking about the fun of being in an adversarial system, is in a civil case, especially if you're at a law firm like all of ours, the lawyers on the other side are well financed. It's kind of an even fight very often. In the criminal system, being up against the government is just an entirely different thing. In some ways, at a big law firm, you have a lot of resources, but in a lot of ways, the rules are kind of stacked against you, and it's your job to fight to make it fair and to win. But there's just a difference going up against the government, and for me anyway, it makes me even more motivated to fight for my client.
Yeah, I completely agree with all of those things. It's shocking to a lot of people that it's still shocking to me after 27 years that in a criminal case where someone could go to jail for a very long time, you can't get to ask the witnesses questions in advance under oath in a deposition. In a civil case where two Fortune 500 companies are fighting over money that's a rounding error on their balance sheet, we can ask everybody every question we want before we get to trial. So that's sort of counterintuitive, but it is, as Eden says, a dramatic difference in the way that two practices are practiced. I have a saying, it's probably completely unfair, and I'm sure I didn't invent it, but I find civil so less civilized. And what I mean by that is, and I have my theories about why that is, but even though discovery is much more robust in the civil system, there is plenty of fighting that goes on. And people write a lot of mean and nasty letters to one another about getting, usually it's about discovery, but it could be about anything. There's a lot more hard-nosed fighting, I'll say. And I think part of that lends itself to something Eden alluded to, and that is, there's more of a balance typically in the parties' respective positions. It's a close case, that's why it's being litigated, and neither side has this inherent advantage like the government has in a criminal case. And so people fight to the death on virtually every issue, and they're not, they don't feel like they have to sometimes be deferential to the government because they hold the future of their clients' fate in their hands. I think the other reason really driving that is it's just a smaller bar in the criminal field. It really is. There's a lot of repeat business. I was downtown today in Lower Manhattan, and in the courts, I just know all the people. There's people I've been dealing with for 20 years. And so it's a lot harder to be a complete jerk to someone you're going to see in 2 weeks or 2 months than a civil litigator who, maybe at Fenwick in the Bay Area, and I'm never going to deal with them again. And, I can be a complete jerk to them. I don't practice that way, but I feel like there's a lot of that in the civil bar and criminal repeat customers. People who are federal prosecutors next week are going to be looking for a job in a big law firm, and the federal prosecutors know that they think they're going to win all the time. So there's not a need to be a complete jerk. All of that goes into, I really feel like there's a difference in the feel of the practice, and I do both. So I do think there's a meaningful difference in just the way lawyers approach the practice, but that's just me.
Great. So our IP litigators, so briefly, what can a student do to set themselves up for a career in IP litigation? Do you need an advanced degree or qualification, or what else can a student do to position themselves in that field?
I'll jump
Like
in.
the first step.
You do need a technical degree in order to qualify for practice before the patent office. So as Alan was saying, if you want to be a patent prosecutor, or if you want to be admitted to practice before the patent office, you actually do, as a matter of kind of qualification, need a technical degree. A lot of people with technical degrees do go into IP litigation. I think it's, I don't know if it's cause and effect or correlation, but that certainly is the case. But I'll say, I was a physics major. I don't handle a lot of cases that deal with actual, scientific concepts that I learned in undergrad. Actually, my insulin case is like kind of the first one I've had recently that does. But, most of what I work on are chemical compounds, and I haven't taken chemistry since 11th grade. So I think it's more about an interest in the material, a willingness to dig in and learn. As Alan said, you're working with experts most of the time. They can teach you. We have science advisors on our staff at Goodwin who help us through the science. And I think it's more about not being intimidated by the subject matter. And some of our best IP litigators, in my experience, are folks that don't have a technical background and therefore do, I think, sometimes a better job of explaining the technical details to someone who doesn't have a PhD in that field. That's just my view, but interesting.
Yeah, I agree completely with everything Alex just said. Because, right, you study something in school, maybe you got an advanced degree, a master's, a PhD. What are the chances that you're going to work on a case that's literally the thing that you studied? Like, pretty low. You might be in the field, which can help because it's easier to understand the tech. You have a foundation. You can easily talk to the engineers or professors or scientists. You might have some anecdotal memory that helps. Like, oh, I remember someone wrote a book on that. I should try to find this textbook. Or I remember working on a project that involves such and such thing. And it's like keywords pop up in your head, like association games. And you can use that to help you in your research. But you do still have to learn. And what Alex said at the end there was very true. Sometimes the people on our teams that are very effective don't have a tech background or have a background that is just not at all in the field. Like maybe a person who is a biology major, but happens to be working on a case that involves artificial intelligence. That's because the people who are familiar with the words and the terms fall into this trap. It's very easy to get too deep in the weeds when you're writing a motion or anything like that, and you can easily lose a judge with overly complex explanations and arguments. So it's really helpful to have people who don't actually have that background sort of do a sanity check and just tell us when we're getting too crazy. I think the end result is better when we have a mix of backgrounds on our teams.
Totally agree.
So Wes, you built a career in a specific niche within litigation. So for students interested in exploring different sub practices within litigation, what advice do you have for looking at a niche like antitrust or other ones?
It cut out for a minute, but I understand what you asked for. So my advice to everyone is, look, if you come to your first job with a real passion, a specific interest in some area, be it IP litigation, antitrust, and your firm wants to specialize early on, then go for it. If you really know that's what you want to do. For anyone else, and I imagine a lot of firms are as well. We start with a generalist pool of litigators, and you really do whatever the demands, send to you. In other words, you could be doing securities litigation, antitrust litigation, a contract dispute, and you get terrific experience all of those disciplines in advocacy. And advocacy is fundamentally what all of litigation is about. So even if you spend a couple of years doing that and you decide, well, now maybe I'm interested in specifically antitrust, all of that work will pay off because we're looking for effective advocates as well. So I think that there's no rush to specialize, and I think you get a lot of benefits from avoiding specializing early in your career.
Great advice. So we're going to wrap up soon. I guess I do want to ask everyone about their firm specifically. I want to take one question that was a good one through the Q&A. This is from Lanil at University of Michigan. We'll have one person chime in on this one. So whoever wants to take it, feel free to just chime in. So what was the most helpful class you took in law school to prepare you for your career right now? I think it's a great question. So whoever wants to chime in, go ahead.
Evidence and legal writing. I got to.
All right, so that was quick. So we could have one more person chime in. It does totally make sense.
Class.
Depositions class, is that very cool?
The trial line class for me was definitely career changing, career directing.
Great. All right. Well, so we're going to move on to the last question. And as we ask this question, we're also going to raffle off some fun prizes. If you haven't signed in for the raffle yet, the link is in the chat. This is your last chance. You have about 30 seconds, so go do it. So Alan, we'll start with you. Now is the chance to plug your firm. In 30 seconds or less, we'll go in order. Why should someone choose your firm? We have a rule here at Summer Associate Hub. The answer cannot be it's the people, because for those who go through the interview process and the networking events throughout the year, you'll notice that it's always the people somehow. So we have a rule here that we have to have a different answer. So Alan, start us off, 30 seconds or less. Why should someone choose Fenwick?
I think it's going to be our focus on technical clients at all stages of the company lifecycle. We have a huge variety of issues ranging from startup, ones that are faced by startup companies to ones that are faced by your Fortune 10s. We go to a lot of trials. We have 10 plus trials for the lit team this year. And we have super flexible teams. So anyone who has an interest and willingness to dig in on whatever part of the case, we welcome that, we encourage that, we support that. And you're ready when you're ready. There's no hierarchy in terms of you must be an X year before you take your first deposition or you make your first appearance in court to argue. And we keep the full teams involved on all of our cases. We don't do a cellular approach. We want everyone to have full visibility into the holistic strategy. And I think that makes a better litigator.
Great. So we have a prize sponsored by Fenwick. It's a mystery swag bag. We don't know what's in it, but it's Fenwick branded swag. It could be a Palm Pilot from eBay. Who knows? So the winner of that, Joyce Ma. Let us know in the Q&A if you're here, Joyce Ma. Make yourself, let us know that you're present to win the prize. Okay, Wes, 30 seconds or less. Tell us, why should a student choose Willkie?
So since I can't talk about the people, and of course everyone will say that they have, it's a great place to practice and, very varied opportunities. I think what I would say is that we are a very transparent firm. So whether you're a partner or a first-year associate, the leadership of the firm likes to tell people what's going on at the firm, how the firm is operated, what the firm's strategy is, what directions we want to go in. And I think that that's somewhat unusual. And I think it's really valuable because it makes everyone at every level feel like they are, invested in the firm and they're respected and they're worth, telling about, where the firm wants to go next.
Great. So Willkie tote bag, the winner of the Willkie tote bag, Satline Core, let us know that you're here. All right. So Ed, in 30 seconds or less, why should a student choose Williams & Connolly?
Sure. So I'll start by suggesting a question I think every person should ask in summer associate interviews, which is not just what a firm's culture is or what sets it apart, but what drives that culture. Because I do think that there are all these firms are amazing. There are a lot of great firms and a lot of great reasons to go to a lot of firms. But I do think that structural things, for example, can affect the culture of a firm. And so for Williams & Connolly, I think the structural thing that drives a lot is that we are a firm that focuses on homegrown talent. Out of 122 partners at the firm, 121 were associates at the firm before they made partner. And that's been consistent across our entire history, and across 60 years, I think we've had 3 lateral partners, and they were all for very specific niches. And it's very unusual. And in terms of why that drives the culture, it means that there's both a tradition of focusing on educating and bringing up the next generation of lawyers, but there's also, a business imperative to do so. We're not in the habit of going around and hiring people from all sorts of different places. And so for us, our firm will succeed if we invest in making sure that after 6, 7, 8 years, whatever it is, the associates who've been working with us are ready to be partners, are ready to be first chair trial lawyers. And so that means that we focus so heavily on pushing experiences down onto the associates, taking depositions, going to trial, doing trial examinations, openings and closings. I did all those things when I was an associate. And the partners I worked with who had people do that for them, they understood that for me to be able to succeed and make partner, in my 30s, I needed to be able to have all those opportunities coming out of school. And I think the reason that people get those experiences at our firm, and I'm not saying you don't get them elsewhere, but the reason you get them at our firm when you do is because the fact that we focus on homegrown talent creates an imperative for us to give people those opportunities and grow them as lawyers.
Great. $25 Amazon gift card sponsored by Williams & Connolly. Lulu Al-Riyadi, let us know that you're here. All right, moving on. Mo, 30 seconds or less. Tell us why should a student choose Wilson Sonsini?
Sure. I think if you look in these books, you'll quickly find out, if you look up Wilson Sonsini, that it's a Silicon Valley law firm that has represented, the biggest names in tech over the years, from Apple to Google to Facebook to every other company you can think of, and also in the life sciences as well. I don't think we're exclusive to that, certainly not anymore. I'm sure Alan would smile at Fenwick. They could say the same thing. I think one thing that I think sets us apart, and maybe not exclusively, again, very entrepreneurial spirit. I think it comes from our clients. We represent, folks like, the founders of Google when they're two guys in a garage. That entrepreneurial spirit, I think, comes across in the way we practice law. And so the firm is supportive about, taking on a representation that, one of the bigger firms might, other big law firms might not be willing to do. And that helps you build your practice. General Motors isn't going to come knocking at your door to do a bet the company case when you're a young litigator. But I think our firm is very supportive of folks, whether they be associates or junior partners, to get behind all sorts of representations, which I think is nice. And then finally, what I would say is, from a litigation standpoint, and this is, again, not universal throughout the firm, but there are many, many cases that we do where there are very, very small teams. I mean, a lot of my matters are me and an associate and a paralegal. And that experience, I think, is unmatched, and certainly nothing like being one of 1,000 people on a doc review. Not to say that's not important and part of the learning process, but if I did nothing but that, it would drive me crazy. So that's certainly something I think you should look for, is like, what am I actually going to be doing on a litigation team, and how long is it going to take for me to do something that is truly meaningful, and something I can learn from.
All right, great. Wilson Sonsini branded Stanley bottle, which is all the rage. I know a lot of people were fighting outside of Starbucks for them. Shraddha Kirwadkar, let us know if you're here for the Wilson Sonsini Stanley bottle. All right, last but not least, Alex, tell us 30 seconds or less. Why should a student choose Goodwin?
So Mo kind of stole my answer a little bit, but I'll say Goodwin, like some of the other firms that we have represented here, has a real strategic focus and interest in representing clients in the tech and life sciences field. And I'll say the same thing. I think that entrepreneurial spirit has really rubbed off on us as a firm. And this goes back to my days as a summer associate at Goodwin. Encouraging even our most junior lawyers to think outside the box and think creatively about not just the type of work, like the substantive work that we're doing, but how we're doing the work. So just to, give an example, my best friend is a partner of mine at the firm, and she and I kind of looked at each other one day and said, hey, do you want to start a fashion and beauty practice? And so we're doing that. And, we have the full support of the firm and our wonderful colleagues in our business development team who have been helping us build that. And that's just something we decided to do. And we didn't need to get, 19 stamps of approval and what have it, go through 4 committees to, do that. We just kind of picked it up and did it. So.
Fantastic. So winner of the Goodwin branded blanket, which is a very interesting swag. I love it. Ian Stapleton, let us know that you're here.
Very popular.
Great. Well, very popular. Yeah. Great. Well, thanks everybody for joining. Reminder that there's a file in the chat with the links to the breakout rooms. So everyone who's here, please download that file and save the links. One thing to mention, all the attorneys and recruiting team members are taking time out of their evening to speak with students. So please join the breakout rooms, engage with them. And one thing to note, bounce around, attend more than one breakout room, hear different perspectives. I think it's a great thing to learn, speak to different people, but also to give everybody kind of the time for taking time out of their evening. So thanks everybody for joining. This was a really insightful discussion and a really good overview of different areas of litigation. So again, make sure to download the file from the chat for the breakout room, and have a great rest of the night. Thanks everybody for joining.
Thanks, Albert.
Thanks, everyone. Thanks, Albert.
Everyone.